This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about how insurance fraud can be a state crime as well as a federal crime, and how states make insurance fraud a crime. In Hawaii, for example, a person was convicted of fraud in State v. Whitaker, a 2007 decision of the Hawaii Court of Appeals. As a result of a claim made by Hiram Whitaker to AIG Hawaii Insurance Company, Inc., his automobile insurance carrier, in which he sought insurance benefits for vandalism damages to his car, Whitaker was indicted, convicted, and sentenced for insurance fraud in violation of Hawaii Revised Statutes and attempted theft in the second degree in violation of another Hawaii statute. At trial, Cheryl Cabrera, an AIG claims service representative, testified that she was assigned to follow up on Whitaker's telephone call to AIG in which he reported the vandalism to his car. She called Whitaker at home, asked him to specifically describe the damages to his car, and requested that Whitaker come in the next day for an estimate. Cabrera recalled that the damages claimed by Whitaker were pretty extensive for a vehicle being vandalized. Quote, "I remember him stating his vehicle, the entire car was scratched or keyed. I remember damages he mentioned to the hood, the trunk, the passenger side and driver's side signal light." Close quote. The damages were inconsistent of a vehicle being vandalized. Every part of his vehicle was damaged, either scratched or indented, and so forth. Both Whitaker and his wife Eva testified at trial. They described the vandalism damages to the car that they observed on March 1 of 2001, and they also acknowledged that some of the damages to the car pre-existed the vandalism. As to the insurance fraud offense, the indictment charged that Whitaker did knowingly present, cause, or permit to be presented false information on the claim to AIG with intent to obtain benefits or recovery or compensation for benefits or services provided, to wit the insurance proceeds. When the definition of an offense specifies the state of mind sufficient for the commission of that offense, without distinguishing among the elements thereof, the specified state of mind shall apply to all elements of the defense unless a contrary purpose plainly appears. Now, not all insurance fraud cases deal with individual acts like that of Mr. Whitaker and his wife. Some involve major conspiracies to defraud insurers by multiple acts of fraud. Consider a case where 46 counts of fraud were charged, and how many more counts could have been charged against the schemers who operated a running or capping scheme to recruit injured persons and inflate their injuries for profit. In New York, a runner is defined as, quote, "any person who, for a pecuniary benefit, procures or attempts to procure a client, patient, or customer, when such person knows, or a reasonable person would know, that the purpose of an owner of a no-fault motor vehicle insurance medical clinic is to falsely or fraudulently, 1. Obtain medical benefits from a no-fault motor vehicle insurer, or 2. Assert a claim against an insured or a no-fault motor vehicle insurer for the provision of healthcare services to such client, patient, or customer, provided, however, that such term shall not include a person who procures or attempts to procure clients, patients, or customers through public media, or a person who refers clients, patients, or customers as authorized by law. Nothing in this chapter shall be deemed to prohibit an agent, broker, or employee of a health maintenance organization from seeking to sell health maintenance organization coverage or health insurance coverage to any individual or group. This is the New York City Administrative Code, Section 20-900, close quote. In People versus Zappoletti, Ramon Alfonso Zanoletti and his wife Magdalene Rosales Zanoletti appealed their convictions by jury of insurance fraud. Specifically, Alonso was convicted of 19 counts of felony insurance fraud, with findings of a pattern of fraudulent taking of more than $100,000 and damages exceeding $50,000. He was also convicted of 1 count of misdemeanor unauthorized practice of law. Magdalena was convicted of the same insurance fraud counts and special allegations, plus another 19 counts of felony insurance fraud with some special allegations. The trial court sentenced each to 22 years in state prison. Magdalena had worked as an office manager at the Franklin Chiropractic Clinic in Los Angeles and received an annual salary of $40,000. Clarence Franklin worked as a chiropractor at the clinic. Magdalena's husband, Alfonso, leased the space for the clinic and also leased some of the medical equipment, including the X-ray machine, and paid the clinic's telephone bill. Alfonso, who was not an attorney, had an office at the law offices of Taguizade and Associates. Between December of 2003 and 2004, Alfonso received $183,115.42 from the law firm in sporadic checks of unequal sizes, often with the notation, quote, for X services. Magdalena testified on her own behalf. She and Alonso had been married 35 years and have 2 daughters. She had worked at the clinic approximately 11 years and denied directing patients to sign for more treatments than they received. She attributed errors in the billings to human error. Alfonso would meet clients at the clinic and also discuss patients with her. Alfonso leased the space for the clinic and paid the clinic's telephone bill. Alfonso testified on his own behalf that he worked at the clinic from 1992 through 1995 as an administrator and again from 2003 to 2006, though he did not recall the time very well. He also began working at the law office around September of 2003, and as to the $183,000 he received from the law office in 2004, he cashed the checks, then returned an unspecified sum to the law office, though he paid taxes on the full amount. The court concluded that multiple convictions were appropriate. Sign-in sheets used by the clinics were clearly fraudulent. Magdalena assisted in the preparation of this documentation as well, and she was appropriately convicted for her role in personally creating such documents with the intent that they be presented in support of a fraudulent claim. Under this subsection, the crime was complete as soon as the writing was completed. The court found that a conspiracy existed when the defendant and another person have the specific intent to commit an offense, and a member of the conspiracy commits an overt act in furtherance of the conspiracy. The existence of a conspiracy may be inferred from the conduct, relationship, interests, and activities of the alleged conspirators before and during the alleged conspiracy. In this case, the evidence was overwhelmingly and established that Alfonso and Magdalena were part of a sophisticated conspiracy to make fraudulent insurance claims. With minor modification in the judgments, the 2 were ordered to serve their sentences. In my opinion, insurance fraud is a serious crime, a felony in most states. Every person convicted of insurance fraud or acting as a runner or capper to assist unscrupulous lawyers physicians and chiropractors to commit insurance fraud should be arrested, tried, and if convicted, sentenced to the full penalty allowed by the state insurance fraud statutes. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog and subscribes. Once you subscribe, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,690 blog postings. You can also subscribe free to the videos on YouTube or on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. You can also follow me at bzelma on Twitter, now called X, and if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.